The bailiff called the case like he was reading a grocery list. And my sister was on her feet before the last syllable landed, not to honor our grandfather, but to claim him. She wore a tailored cream coat over black, the kind of quiet luxury that makes people assume you're right before you speak. Her hair was perfect, her face dry, and when she looked at me there was no grief in her eyes, only calculation. Her attorney's slick suit, soft voice, expensive watch walked to the counsel table and slid a thin stack of papers forward like a blade. Your Honor, we're moving for immediate transfer of the estate to my client. Effective today, he said, while my parents nodded behind him in perfect unison. My mother folded into solemnity like she was in church, and my father staring straight ahead as if this were a business meeting and I was the obstacle. The judge didn't look at them. He looked at me. Miss Vale, do you object? My sister's lips twitched, waiting for me to beg, but I sat up straighter, placed my hands on the table, and said yes, I object, just not yet. I wanted to wait for the last person to arrive. They laughed it off, called it ridiculous, accused me of delaying, my father muttering that I always embarrassed the family. But I stayed calm and told the judge they were asking him to act without the full record. As his patience thinned and he glanced toward the doors, the courtroom opened not dramatically. Just a controlled push, and a man in a plain black suit stepped inside, carrying nothing but an envelope and an air of indifference to who had money in the room. He walked straight to the clerk, said my name, and placed the envelope down. This is for the court, from the trustee. The judge stared at it like it didn't belong, then opened it carefully and read the sender aloud, Hawthorne National Bank Trust Department. My sister's composure flickered, because a bank doesn't care about control the way families do. It cares about documents. The judge continued, explaining that the assets were held in a revocable trust that became irrevocable upon death, silencing her attorney with a single command to sit down as he turned the page. And this, he added, his voice even flatter, is a certification of trust identifying the trustee. He paused, as if the next line offended his sense of how lawsuits were supposed to work, then read it aloud. Successor trustee. Hawthorne National Bank Trust Department. My parents stiffened. They had been aiming for control. And a bank doesn't care about control the way families do. It cares about documents, conditions, and risk. My sister's attorney tried to recover, insisting probate still had jurisdiction, but the judge finally looked up. Counsel, your motion requested immediate transfer of all inheritance, he said, tapping the paper. This certification states plainly that the probate estate is minimal and the bulk of the assets are held in trust. He marked it received, then looked at my sister not as family but as a petitioner who had tried to seize something she didn't control. Miss Vale, did you know your grandfather established a trust with a corporate trustee? She lifted her chin and claimed influence. Lack of understanding, but the judge simply turned the page. Reading the execution affidavit, the witness list, the attorney's certification of full capacity, until he reached the line that made him slow. No, contest clause triggered, he read carefully. Any beneficiary who petitions contrary to the trust terms forfeits their distribution. Her attorney went pale. My sister's eyes narrowed as if she could intimidate the paper itself. And the judge addressed counsel evenly. Filing this motion may already have caused forfeiture. When the attorney objected, the judge cut him off. You can dispute it, but you don't get to pretend it isn't there. He turned to me. Was this the person you were waiting for? Yes, I said steadily. The trust department controls distribution. The man in black confirmed the trustee would not recognize today's motion or distribute assets through probate. And when my sister tried to interrupt, the judge shut her down. Her attorney pivoted to allegations of undue influence, but the judge reminded him that evidence of coercion existed and it hadn't come from me. When the trustee confirmed the full trust had been delivered yesterday, the room understood what that meant, and the judge ordered hearings on standing and sanctions, warning my sister coldly that if she had triggered forfeiture, it may have cost her more than she intended. That was when she abandoned paperwork and reached for narrative instead, turning loud and urgent, asking to put something on the record, then firing the word her parents had been holding like a bullet. Elder abuse, and the courtroom shifted. Not in belief, but in consequence, as the judge leaned forward and asked the only question that mattered. "What evidence do you have today?" "Witnesses," she said, gesturing behind her, where two relatives stood awkwardly near the back rows like they'd been drafted, my aunt and a cousin I barely spoke to, their faces tight, eyes refusing to meet mine, while my mother nodded at them encouragingly, silently coaching. The judge barely glanced their way. "Witnesses can testify," he said, unimpressed. "But I want something concrete: medical reports, prior complaints, police involvement, APS records. Anything." My sister pivoted fast, claiming he didn't want to embarrass the family, that he'd been scared, but the judge's expression stayed flat. "Then explain why he called emergency services himself." Silence. She tried again, saying he was confused, but the judge glanced at the bank's envelope and replied evenly, "This trust was executed with a capacity affidavit and witnesses. That is not confusion. That is formalized intent." My father's attorney rose smoothly, alleging I had controlled accounts and communications, but Elliot objected immediately. "And when the judge asked if they had that evidence today?" My sister's attorney hesitated and asked for discovery. The judge's eyes hardened. "Discovery is not a fishing license. You do not accuse someone of elder abuse in open court as a strategy to seize assets held in trust." My sister snapped that it wasn't a strategy, and the judge leaned back and said calmly, "Then bring evidence. Not theatrical relatives." My mother tried next, voice trembling on cue, accusing me of keeping them away. But the judge shut it down. "Ma'am, this is not family therapy," and turned to the one person without emotion in the room, the trustee. When asked if there were any concerns of undue influence, the man in black answered no, explaining the decedent met privately with counsel, confirmed intent, and provided supporting materials. "Supporting materials?" the judge asked. "A log and a statement," the man replied, "preserved at the decedent's request." My sister demanded to know what statement, but the judge ignored her and ordered it produced. A thin, unmarked envelope appeared, and the judge read the single-page letter silently before looking at me with the weight of understanding. "Miss Vale, did you know your grandfather prepared a written statement anticipating today's allegations?" I said yes, quietly, that he told me, but I didn't know what he wrote. The judge read the first line aloud. "If you are reading this in court, it means my son and his family tried to take my estate by accusing my granddaughter," and the room collapsed into silence. As he read enough to make the record undeniable, my grandfather asked me to move in. Met with counsel alone, created the trust to protect himself from pressure. And then the line that made the judge pause before reading it aloud: "On the night I called emergency services, my son brought a mobile notary to my home for new signatures. I refused. I asked for witnesses. If they call this elder abuse, they are projecting their own conduct." My sister sat frozen, eyes flickering like she was searching for a way out of the record. And when my father's attorney objected to hearsay, the judge cut him off, ruling it admissible as intent and consistent with dispatch audio. He dismissed the elder abuse claim, denied the motion, set sanctions, and when the attorney tried to withdraw, replied coldly that consequences don't withdraw. As my sister hissed that I got everything, the judge corrected her no. The trust would be administered per its terms, and the trustee added calmly that distributions to anyone who triggered the no contest clause would be suspended pending review. My sister shook now, gripping the table, whispering it wasn't over, just before the bailiff leaned in and spoke quietly to the judge, whose expression shifted as he nodded and looked straight at my father. "Mr. Vale," he said, "remain seated." My father froze. "Why?" he asked. The judge's voice stayed flat. "Because," he said, "I've just been informed. There's a deputy in the hallway with paperwork for you, and it isn't from this court." My father's face tightened as the doors opened again and a uniformed deputy stepped inside holding a document with a bold header I couldn't read. But I didn't need to. My father's skin went gray the moment the deputy said, "Sir, you've been served." He didn't stand or argue. He just stared at the badge like it suddenly weighed more than his money. When he asked what it was, the deputy held the packet out calmly. "Service of process." You can accept it here or in the hallway. My father ignored his attorney's whisper and snatched the papers, flipping the page with shaking fingers, freezing as he realized this wasn't probate, it was criminal. The judge watched without expression. This court has nothing to do with that paperwork, he said. But I'll remind you that you are still under oath. My father tried to call it harassment, but the judge cut him off sharply, listing facts one by one. Your daughter didn't call emergency services, didn't file a false motion, didn't attempt to seize trust assets. My mother whispered that they were trying to protect the family, and the judge replied evenly, then you protected it into a referral. I noticed then the other deputies by the door present, waiting. When my sister's attorney asked for a recess, the judge dismissed the motion, confirmed the trustee's authority, set the sanctions hearing, then paused and asked the trustee if a protective order was requested. It was granted, the judge said, ordering it drafted and signed that day. My sister scoffed at the word harassment until the judge reminded her she'd just accused someone of elder abuse without evidence. My mother whispered that they couldn't be kept from their daughter, and the judge replied, you can keep yourselves from committing misconduct. When court recessed, my mother hissed that I ruined my father, and I told her quietly he'd done that himself. My sister promised I'd lose everything, and I answered calmly that she'd already tried and failed because you can't bully a record. She turned her phone face down, cold and deliberate, and Elliot murmured for us to leave. Outside, the air was sharp and indifferent, and at the curb he looked at me steadily. Here's the ending you wanted, he said. The trust controls everything. The petition is dismissed. The no contest clause was triggered, and the court signed an order preventing my parents from interfering with the trust. My sister, Elisa, likely forfeited her share, and within minutes of the hearing ending, a security alert confirmed she had tried and failed to access the trust portal. Elliot immediately froze all changes, routed communications through counsel, and generated a record of her actions. The trustee formally confirmed Alyssa's forfeiture, and my parents' contingent distributions were put under review for interference. Weeks later, the court imposed sanctions for the bad faith filing, ordered my sister to pay part of the attorney's fees, and acknowledged the trustee's enforcement of the no contest clause. The first distribution under the trust terms went through flawlessly. The house remained protected, and all assets were administered with receipts and confirmations, leaving my family unable to rewrite the record. In the end, my grandfather's foresight had ensured that courts reward proof, not confidence, and when people try to erase you with a story, only documented fact can stand.